President, please be seated.
Veuillez vous asseoir.
President, this is the third day of the appeal hearing. Grafchi, could you report on the attendance of the parties to the proceedings? Grafchi, good morning, Mr. President, Your Honors. Good morning, everyone in and around the courtroom. All parties to the proceedings are present. For the prosecution, we have Madame Chia Lin and Mr. Nicholas Kumchien. The two accused, Nguyen Chi and Kee Sampont, attended the proceedings. However, Nguyen Chi requests to waive his rights to be present in the courtroom. And we have Sun Arun, the National Counsel for Nguyen Chi, and the International Counsel is absent, that is Victor Copper. And for Kee Sampont, we have Mr. Kong Samon and Madame Anta Guichet. For the co-prosecutors, for the lead co-lawyers, we have Pek Ong and Mary Giraud. We have 13 civil parties who are present, including Madame Phun Pala, Mr. Kham Naret, Madame Su Sothivi, Mr. Javni, Madame Pok Saem, Madame Pek Sri Paul, Madame Chum Kung, Mr. Yu Paul, Madame Long Yon, Mr. Pon Sopat, Mr. Sang Arat, Madame Sain Si Buddha, and Mr. Bun Chun. Thank you. President, this morning the accused Nguyen Chi waived his rights to be present in the courtroom, and the waiver is attached with a medical certificate by the duty doctor. The reason the chamber grants Nguyen Chi to his request to follow the proceedings remotely from the holding cell downstairs. I instruct the AV unit personnel to link the proceedings to the room downstairs so that the accused can follow. The chamber would also like to inform the parties that yesterday we adjourned at the proceedings on the fourth semantic sessions, that is on the accused individual criminal responsibility. However, we actually skipped a session where questions had to be put by the chamber, and this morning, if the defense counsel and the co-prosecutors wish to make further submission on this semantic session, you may have the floor. As for the questions put to the co-prosecutor by the bench, the floor is also given to you to make your response to those questions.
Thank you, Your Honors. We do have some brief comments to make in regards particularly to the question that Judge Millard posed to us by email. We'd like to expand upon our answer to that. But just before I forget, I just wanted to add one brief remark regarding the defense submission that the evidence was insufficient to show that the zone armies were under the control of the center. I think one of the pieces of evidence that absolutely and clearly shows that these zone armies, one of many pieces of evidence, that these zone armies were under the control of the center, is the undisputed fact that after the April 75 victory, the center took units, divisions, and the other units from each of the zones to form a central army. If these were independent militias, they wouldn't voluntarily comply with an order to give their troops over to the center army. So this is just another one of many, many facts that show indisputably that this was a hierarchical military force controlled by the center, controlled as the DK Constitution provides by the party. Going back to the question that was posed by email regarding whether it's necessary for the judgment to have found individual murders beyond a reasonable doubt.
Mr. Prosecutor, maybe the public could benefit from you reading the question in full, that one that was posted on email, because it's not necessarily the same. On email, I was asking which murders, according to the prosecution, have been proven beyond a reasonable doubt, in particular with the reference to pieces of evidence on file. I mean, relied on by the trial chamber. Thank you. So as for the standard, we were satisfied that you answered in full, but in regards to this email question, we were interested to know which pieces of evidence you consider particularly persuasive.
We planned to do that, but if I could, I would also like to expand upon our view of why it would be correct for the trial chamber not to have entered findings regarding individual murders beyond a reasonable doubt. Certainly there were findings about murders, but again, our position is that it's necessary to make a finding whenever an incident is charged separately under a legal characterization, to make that finding beyond a reasonable doubt. So in this case, for example, the trial chamber made findings about killings during the first forced transfer and killings by the conditions that were imposed upon people during the second forced transfer, and also killings at Tulpo-Tre. I would point out that actually the chamber did not impose any murder conviction in this case, because they found in the end that the murder charge was subsumed by the extermination. They found, I believe correctly, that extermination includes all of the elements of murder plus the additional element of killing on a large scale. Therefore, they declined to enter the convictions. It was subsumed under extermination. But if I could briefly review a few other authorities on that I didn't get to yesterday. And for the interpreters, these are in my notes on question 3, so if I know that they're going to have some trouble with some of the names or my pronunciation of the Rwandan cases. In the appeal judgment in Natiki Utimana, the appeals chamber said that it agreed that customary international law does not require a precise description or designation by name of victims to be an element of extermination. In Rukunda appeal judgment at paragraphs 187 and 189, they held that, the same appeals chamber held that it's sufficient that the trial chamber, quote, had a reasonable basis for concluding that killing on large scale occurred, unquote. even when no evidence was adduced before the chamber regarding the specific number of deaths. In light of the general context of systematic targeting and killing of Tutsis in the city, and the overwhelming evidence of abductions and killings of Tutsis in a nearby city, they upheld that finding, that conviction for exterminations in paragraph 190 and 191. Counsel mentioned stockage. In the trial judgment in stockage, the court found simply that that the number of deaths total can never accurately be calculated. In paragraph 654, they said that they simply found that on a conservative estimate, more than 1,500 persons were killed. And I think there's very interesting language in Jakum Bitsi appeal judgment, paragraph 89. In that case, the prosecution had pled in some detail the killings. The appellate argued that the trial chamber should not have convicted him of extermination because the prosecution had failed to prove that the individuals specifically mentioned in paragraph 28 of the indictment were killed at this parish. The appeals chamber said it disagreed. Such a showing was not required for an extermination holding. So it's our position that the trial chamber was not required to make findings beyond on an individual basis for each killing. Instead, they did what they were supposed to do, look at the elements of murder or exterminations based on the totality of the evidence for each incident and make a finding beyond a reasonable doubt that that element was met. Now, I'm going to ask my colleague, Mr. Lysick, to address some of the evidence that we submit shows the power of the evidence that was presented and its capability to support even individually convictions of murder beyond a reasonable doubt.
Good morning, Your Honors. As I set up here, I have a number of instances where evidence was heard of killings relating to the evacuations in response to your question, Judge Millard. And the first one came from a witness, pardon me. We heard from Yim Sylvan in this trial, testified in court on the 19th of October 2012. This is a witness who was evacuated from Phnom Penh. He describes, and this is at 1420 and 1427 of his testimony on the 19th of October 2012, how he witnessed a car on the road that apparently had run out of gas and people were pushing it. And the Khmer Rouge soldiers were not happy with this. They removed the driver from the vehicle and shot him to death. The same individual, Yim Sylvan, also witnessed killings of a group of civilians who had locked the door to their house in Phnom Penh. And when the Khmer Rouge soldiers arrived, they shot the lock, took them out, and shot these people. This is in his testimony, same day at 1416. There are accounts, corroborative accounts from others of similar experiences where people who refused to leave were executed. These come, though, from people who submitted complaints, written interviews, or civil party applications. There are 48 accounts, Your Honor, that were relied upon by the trial chamber of civilians who were killed during the first evacuation, the evacuation of Phnom Penh. 48 accounts, 32 of which were direct eyewitness accounts, 11 which were given via live testimony, the others through corroborative documents, civil party applications, OCIJ interviews, or contemporaneous documents. And these 48 accounts are, for your reference, described in detail in paragraphs 145 to 148 of our appeal response. The other, in relation to the killings of civilians in the first evacuation, the other I would like to point out to you, to your honors, civil party Cheng Eng Lee testified about crossing the Monavong Bridge while being forced out of Phnom Penh, and witnessed a dead woman on the road whose baby was still alive on top of her. This is what she said, and this is on the 29th of May 2013 in this courtroom at 1532 to 1534. Quote, "When we were leaving Phnom Penh and we were traveling along National Road number 1, crossing Monavong Bridge, I saw a crying baby. He was actually crawling over the dead body of his mum. I wanted to carry that baby. I wanted to take the baby. But all of a sudden, the soldier carried the baby. They just tore the baby apart. It was a very horrifying scene. I could not imagine any human being who would do that." End of quote. Your Honor, an example where we believe evidence was proved of civilians, people who died because of the conditions, directly as a result of the conditions of the evacuation. This was Pek Sray Paul, who testified in this courtroom on the 5th of December 2012. And she testified about the death of her baby during the evacuation. This is at E1/148.1, testimony from 10:01 to 10:06 in the morning of the 5th of December 2012. Quote, "While en route during the evacuation, the Khmer Rouge soldiers did not give us any food, water, or shelter. We left without bringing sufficient food or belongings with us. We used tree leaves to cover the ground, and we slept on it. And the food that we brought with us was for a 3-day period and was almost gone. During that period of time, I had a relapse after my baby delivery. I had no breast milk to feed my young baby, and I did not have medicine, and I did not have milk. I could only afford water to feed my baby. Unfortunately, my baby died during that evacuation, and I did not even know what to do with my dead baby. I was instructed to bury my baby in the forest. It was like an animal." End of quote. Your Honors, understand the law. We've already discussed the law from Celebici cases that wrongdoers take the victims as they find them. Your Honors are aware of the circumstances of the evacuation, where people were ordered to leave, told they were only leaving for 3 days, and therefore left without food, without sufficient resources. and no help was provided to them by the Khmer Rouge. The same person, Pek Sray Paul, also provided another important evidence of killings, deaths that resulted during the evacuation. And that is specifically seeing people who had been taken out of hospitals who died in the process and were on the roadside. And this is in her testimony again on the 5th of December 2012 from 9:49 in the morning to 9:53. She said, quote, "During the course of my trip, I saw a lot of people on the road, and people were marching, walking from the Russian hospital. I could see that some people, in particular patients, were pushed on the hospital beds when the IV fluid was still attached to some of them. When we were leaving, and by the time we got to Stung Mianche, we saw some dead people on hospital beds. These people seriously sick, and because of such situation, they couldn't make it, and the dead bodies were left unattended." Your Honors, when you force patients to leave a hospital, no matter how sick, and to travel by foot into the countryside, you know that many of these people are going to die. This is what a British journalist, John Swain, who was there in Phnom Penh at this time, wrote in his contemporary journal when he saw this very scene at 7 a.m. in the morning on the 18th of April, 1975. This is document E3/51. Let me give you some ERN references. English S00003279, Khmer S00644-713, French 00597-837-38. This is what John Swain wrote when he saw this scene. Quote, "The Khmer Rouge Army is emptying the city and its hospitals, tipping out patients like garbage into the streets. Bandaged men and women hobble by the embassy. Wives push wounded soldier husbands on hospital beds on wheels, some with serum drips still attached. In 5 years of war, this is the greatest caravan of human misery I have seen. The Khmer Rouge must know that few of the 20,000 wounded will survive. One can only conclude they have no humanitarian instincts. The entire city is being emptied of its people, the old, the sick, the infirm, the hungry, the orphans, without exception." End of quote. And in response to your question, Judge Millard, I want to give 2 or 3 specific examples of Lon Nol officials, top Lon Nol officials, whose killing was certainly proved beyond a reasonable doubt. And I speak of Long Beret, Lon Non, brothers of Lon Nol. Long Beret was, of course, the Prime Minister, and Sariq Matak, who was the Deputy Prime Minister. The killings of these people, of course, are of particular importance to why we are here today, because on the 26th of February, 1975, a statement was broadcast on the radio by Q Sampan. This is it is recorded in document E3-1117. And the statement from Q Sampan broadcast that day stated, concerning the 7 traders in Phnom Penh, The National Congress has decided as follows. Traders Lon Nol, Surik Matak, Son Nyok Tan, Chen Heng, In Tam, Long Beret, and Soten Fernandez are the chieftains of the traders and ringleaders of the treacherous anti-national coup d'etat which overthrew the independence, peace, and neutrality of Cambodia. On behalf of the FUNC, GRUNC, and CPNLAF, the National Congress declares it absolutely necessary to kill these 7 traitors for their treason against the nation. We heard Khieu Samphan's counsel the other day say there was no evidence of Khieu Samphan's intent to kill anyone. Well, you could not have more clear evidence of intent to kill than an announcement broadcast on the radio repeatedly calling for the killing of the top leaders of the Lon Nol regime. You cannot have stronger evidence of intent than that. And we heard testimony in this trial about what happened to these individuals, the 2 specific of the 7 super traders who remained in the country, Long Beret and Surik Matak. We heard testimony from Al Rokoff, from Sidney Schanberg, and some others. And there are numerous contemporaneous documents as well that establish exactly what happened to these individuals. Let me briefly take you through it so you have some sense of the proof. In the case of Long Beret, on the day of 17 April, there was a radio broadcast calling for the officials of the Lon Nol regime to surrender themselves at the Ministry of Information. The radio broadcast specifically also indicated that both the troops, both leaders from the North Zone and East Zone militaries were to report to that location. Both Al Rokoff and Sidney Schanberg went there about 4 o'clock in the afternoon, and they testified that there were about 50 people, 50 prisoners who had been gathered at that point, including Lon Non, Long Nol's younger brother, and several generals. Sidney Schanberg identified one of them specifically, Brigadier General Chim Chun. You'll find the testimony of Schanberg and Rokoff. Rokoff's testimony on the 28th of January 2013, E1/165.1, from 11:29 in the morning to 11:57. Sidney Schanberg, who, as you know, was the New York Times reporter who was in Cambodia at the time covering the war. The 5th of June 2013 at 10:50 in the morning to 11:02 is where they describe the scene at the Ministry of Information. And they were both present when Long Beret, one of the 7 traders, arrived there and was arrested by the Khmer Rouge military. You'll also find in Sidney Schanberg's testimony and also in the contemporaneous diary of John Swain that I've mentioned earlier, an interesting account when they confronted the person who appeared to be the leader of the Khmer Rouge military to find out what was going to happen to these people. And the response was very significant. It was, the political leaders are coming here in a few days, and they will decide what to do with these people. These were not revenge killings. This was organized. These were people in radio who had radios who were in contact with the leaders. the evidence on this is very clear. Sariq Matak, the other super trader who remained in Phnom Penh, managed to make it to the French embassy. He was there. Several other the top Lon Nol officials were there too, including the President of the National Assembly, Ung Bun Hur, and 55 representatives of a group called Fulro. Some of you may know what Fulro was. Fulro was an organization of ethnic minorities who had fought from the mountainous region on the border of Cambodia and Vietnam, who had fought against both the Vietnamese communists and the Khmer Rouge. Their leader was the former governor of Ratnakiri province. He was also there at the embassy, and they had sought asylum. And again, we have both testimony from Al Rokoff and Sidney Schanberg, who were there at the embassy, and we have numerous documents from the French consul who was there at the embassy, who was sending reports to his country on what was taking place, that document exactly what happened in that period. Let me just give you relevant, starting with the relevant documents that were sent by the French consul, E3/96, strike that, E3/2694, E3/2702, E3/2700, E3/2706. These document the procession of events when these people who were seeking embassy had to be turned over because of threats by the Khmer Rouge forces that they would otherwise storm the embassy. And there are detailed accounts of Sariq Matak leaving the embassy and being taken into custody by the Khmer Rouge forces. Not renegade forces, people who were the official representatives of the Khmer Rouge in the city, who were actually called the city committee. And finally, we know what happened to these people. We have admissions and announcements that were made. Ieng Sary, in November, early November 1975, was in Bangkok for meetings with leaders there, and he held a press conference. And at that press conference, he announced that Long Beret, Sariq Matak, and Lon Non had been executed. The Bangkok Post article where you will find this is E3/604. There were numerous other press reports of the same conference and statements by Ieng Sary, including one from the Washington Post. So an announcement by the government that these people who Khieu Samphan had called for the execution had in fact been killed. Both of the accused in this trial have made statements in the past showing their knowledge of this also. Khieu Samphan, in an interview in September 1976, which is document E3/608, stated in that interview, I quote, "Those traitors who remained in democratic Kampuchea have been executed." Noon Chea, in his interview by Tet Sambat that is on videotape in evidence, E3/4001R, E3/4001R at, it's the video called One Day at Potre, at 22:07 to 22:11, in response to questions from Tet Sambat, confirms that the top leaders of the Lon Nol regime were liquidated. We believe, Your Honors, this is proof beyond any reasonable doubt of the killings of the very top leaders of the Lon Nol regime, killings that are directly connected to both accused in this case.
Just a moment, Counsel. Sorry, we are seeking the relevant parts of the trial judgment. It's not that we were not listening to you to see if indeed the trial chamber relied and to what findings on these pieces of evidence. It is like my impression that the trial chamber says in a footnote in its discussion of the policies that it was subsequently reported that these officials were executed. But if you can point me to a more precise finding of the trial chamber.
Some notes on that, Your Honor. I'll tell you that they were prepared for me, so I don't know which part.
It's not urgent. We will look for them anyways.
Okay, but I do have, I didn't understand you wanted me to cite the judgment findings, but.
Because
okay.
It was my understanding that the officials are being addressed in case 2.
No.
And anyway, as far as I'm, sorry.
That is not correct, Your Honor. We heard the killings of these top Lon Nol officials who were taken in as part of the evacuation of Phnom Penh was very much part of the first trial. And I have references here to paragraph 503 of the judgment, which I think has to do with the top officers.
This is the one that I'm looking at.
Yeah, and then I have a number of others, but I know this evidence is discussed at various parts of the judgment, so I'm happy to do some searches.
We'll search it anyways. Thank you very much.
Yes.
So.
Bonjour et merci.
Good morning and thank you, Mr. President. Since you have invited the parties to respond and to make submissions in relation to the questions asked by Honorable Judge Millard yesterday, I would like to seize this opportunity. First of all, since yesterday we're talking about the responsibility of Mr. Khieu Samphan, and since I've been telling you since yesterday about the link, the nexus between the crimes referred to and Mr. Khieu Samphan himself, as regards the decision on evacuation, I would like to reiterate what I stated and provide more precise information on what I think. I cannot say that the pleadings of the co-prosecutors is nothing but rhetoric. I cannot but say so because, in any case, we are appearing before you after a closing brief at first instance, and after the pleadings before the trial chamber, and after the appeals brief, which are very circumstantial, which you have read. And it is not in a few minutes when we talk on the general approach of evidence that we can give you very precise remarks here. But since that point was dealt with yesterday by the deputy co-prosecutor, I would like to talk about the evacuation decision again and about the basis for the chamber's findings. First of all, as regards the particular and extraordinary credibility that the deputy co-prosecutor mentioned yesterday with regard to witness Pipun, alias Prochenton, as I invited you to do yesterday as well, and to truly go and see the video footage, because when you look at the transcripts, it is not very easy to grasp the atmosphere and the reaction of the witnesses, so you need to see the video footage. But as regards the statement of the witness in question, contrary to what the co-prosecutors have said, we have not engaged in a rhetorical exercise. We have looked at the final closing arguments to see the difficulties that arose during those proceedings. We should note that the chamber, in its judgment, is mixing up two meetings and converting those two meetings into one meeting, whereas that witness talked of two meetings. The first meeting was in June 1974, during which the witness said, and I'm not the one saying it, that the issue of evacuations was not addressed. And he then talks of a second meeting, the famous meeting held in February 1975 at B5, and he says that on that occasion, the issue of evacuations was addressed, and not in detail, and it's his document E295/6/4, paragraph 21. That is a trial chamber decision, which means that the trial chamber was particularly informed of this evidence. When he was asked, is it possible that the evacuation of Phnom Penh had already been discussed during the first meeting in 1974? The answer he gives on 30th of June 2010 at about 13:38 and 10 seconds. I do not think it was the subject of discussion, he says. And this is what he says again. This time is the 31st of July 2012, document E1/99.1 at 9:43 and 40 seconds. I heard only on one occasion at B5 that it talked about it. I do not have any other details on this subject, end of quote, free translation. And when he talks of the second meeting in April 1975, with regard to the participants at that meeting, and he says that Khieu Samphan attended that meeting, and this is what the witness said. They talked of the evacuation of the town, but did not give any details at that meeting. And here we are on the 30th of June 2012, document E1/98.1, and it is at about 15 hours, 22 and 41 seconds. Why are these statements important, aside from the fact that the chamber mixed up the two meetings because it suited the chamber? We should say that that was as of 1974, Khieu Samphan attended major meetings and took part in these decision-making sessions. Why did they talk of the evacuation of Phnom Penh as atrocious things happened then? People says they did not talk about details of the evacuation, which means that they did not talk of the conditions at the time. Even if Khieu Samphan had been present, which is not established, even if he was present, we do not receive any details at that meeting as to how the evacuation unfolded. That doesn't mean that at the time they knew that they were going to take people out of hospitals and so on and so forth. There are no details provided. This is the key witness of the prosecution who says so himself. And this brings me to a second point. Why, again, does the trial chamber talk of the recurrent pattern of conduct and of evacuations that took place before that of April 1975? Because it needs to establish this recurrent pattern of conduct, and which will make them say that they knew that Khieu Samphan was aware of the manner in which the evacuations were carried out. And the chamber and the co-prosecutors forget one key fact, because when you talk of evacuations prior to 1975, we are confirming it as a reality, which is not the case. we are in a situation where there's fighting between Lon Nol's army and the Funk and Gronk armies. It is not the same situation. And when we are told that he should have known because there had been evacuations before, let me remind you of the evidence on record. And I refer you, for instance, to the examination of a certain Nikam at the hearing of the 20th of May 2012 at 10 hours 21 and 20 seconds, who says the population was evacuated because of the war. I'm not the one saying it's a witness, saying it's Mivun on the 3rd of October 2012 before 3 p.m. This is what he states precisely. He says that at a point in time, only Khmer Rouge and Lon Nol soldiers were there and fighting with one another. He says earlier that on the battlefront along National Road 5, people were fleeing to the liberated zone. People didn't stay close to that national road. Only Lon Nol and Khmer Rouge troops were there fighting with one another. That is at the hearing of the 3rd of October 2012, somewhat before 15 hours 45. So we have a conflict between Khmer Rouge and Lon Nol's armies, and we are talking about a situation that happened before 1975. So we have a problem here. At the same time, you're talking of a speech by Khieu Samphan at the time when they are going to have the offensive of Phnom Penh. And I heard yesterday on several occasions the co-prosecutor, the international co-prosecutor, say that yes, it appears that even Khieu Samphan appears to have added names to the list of traitors. Why? These are the traitors who staged a coup d'etat in 1970 against the Sihanouk regime. Sihanouk, who was the leader of the Funk and the Grunk. And that is the only person who talked about other names apart of those traitors was the late King Sihanouk himself. And I refer to document E3/120. Contrary to what the co-prosecutor said, it's not Mr. Khieu Samphan who talked of other traitors. He only referred to Mr. Khieu Samphan in that so-called speech delivered on behalf of the Funk and the Grunk. And at the time, it was indeed the king, Prince Norodom Sihanouk, who was the head of the Grunk and the Funk. Let us look at document E3/120. He's the one who refers to traitors on several occasions because these are the traitors who staged a coup d'etat against him and forced him to go into exile. That is the context we are dealing with, and when Mr. Khieu Samphan delivers that speech. And here again, the co-prosecutors are not telling the truth because they talk about people on the side of Lon Nol who came to join the ranks of the Grunk and the Funk. And they say you can engage in sabotage, you can join the movement. We are soon reaching the end. They are not saying that they'll kill everyone. He's not saying that they'll kill everyone. He talked of those traitors as part of a regime that staged a coup d'etat against Prince Norodom Sihanouk, who was the Funk leader. That is the context in which he made those statements. To take those elements out of the context and say that this is the germ of the intent to commit a criminal offense on the part of Mr. Khieu Samphan, and a few months later, they will relate this to the atrocities at Tupotke, whereas the chamber knew that he wasn't there at the time. Say that there is a serious derogation from the law, and it's a serious violation of the rights of Mr. Khieu Samphan. You cannot use such factual elements to reach a finding of guilt. Let us remember that we are dealing with a situation before 1975, and it is an armed conflict we're talking about. There is an evacuation. People are fleeing, fighting. There is war raging. And yesterday, we were presented with a speech by Mr. Khieu Samphan after the victory of the Grunk, when the troops of the Funk and the Grunk had won the battle, a very important battle. And in this context, you are telling us that he shouldn't have rejoiced. Explain to me in which armed conflict you do not say that we have won the war and we are happy to have won against the enemy camp. So it is sad, it is terrible. During the war, people die, unfortunately, But the enemy during the war is the person in the opposing camp. It is the person who is a soldier and who is a member of an armed force. And this is the context in which Mr. Kiir Samban delivered that speech. And to use this speech to say that he subsequently supported a policy against the enemy after the armed conflict is an egregious error. And this is a point that we must take into consideration. Another remark as regards, of course, I talked of people on the issue of evacuations, since the co-prosecutor yesterday referred to other evidence that may have been relied on by the trial chamber to corroborate its findings, and that is the term used by the chamber to corroborate the statements of Pipon. Let us remember that Pipon talked of two meetings. The first meeting was in June 1974, and they didn't talk about the evacuations. But we are told that the chamber also used the statements of Nunchia. Nunchia spoke on several occasions. He never said that Kiir Sampan was present at any meeting during which the evacuation was discussed, or the decision to evacuate was taken. I'm referring to paragraph 274 of our appeal brief. Furthermore, when I presented the manner in which the chamber distorts the evidence, you do not have to agree with me on the fact that the chamber may have been right. I am using the element that the chamber relied on and telling you what the chamber said regarding that evidence. Paragraph 280, let me remind you of what the chamber said. It said that they considered that it's very probable that the date of the meeting in June 1974 was set to enable Ieng Sari and Kiir Sampan to attend them and to present to the Central Committee very fruitful results of the meeting with senior officials of the Chinese government, and relying on this assertion and the probability, because the chamber wasn't sure, there is no specific date on which Kiir Sampan is supposed to have returned to attend that meeting. Kiir Sampan and Ieng Sari, they use Song Sikun, who do not say that Ieng Sari and Kiir Sampan attended the meeting, paragraph 276 of our appeal brief. Song Sikun said that at a point we were there at the center and we saw them leaving for Vietnam. Does he remember the date on which they returned to Cambodia? Absolutely not. Does he tell us what they were able to do at that time? Not at all, but the chamber extrapolates on this and claims that this is for corroboration purposes. Ieng Sari, who was quoted yesterday by the co-prosecutors, said the following: the chamber relies on the statements of Ieng Sari to reach the following findings, and that is paragraph 217 of our appeal brief. They say that he is convinced that such a discussion indeed took place some time after the meeting in question. And during those meetings, what evidence does the chamber rely on to say that the discussion took place at that time? Nothing. What is said, and I refer you to footnotes 657 in the interview with Ieng Sari, with Heather, and Ieng Sari refers to his meeting with Pol Pot and says that nothing precisely had been decided in 1974. And when Mr. Ieng Sari talks of his discussion with Pol Pot, he doesn't say that the decision was taken. This is, by the way, what he states in his discussion with Pol Pot. I responded that to evacuate everyone, and how? And he's saying, he's talking about Pol Pot. Let us look at the situation in practical terms. And his answer was that we should wait and see how things work out in practical terms. And then Ieng Sari says on page 6, I did not attend any decision at which a decision was taken.
Qu'elle est convaincue.
This is the evidence the chamber relies on to say that a decision was taken during the meeting, and even in the course of that meeting. That is what Ieng Sari says.
Ensuite,
Then, and I'd like to refer to our developments in our appeal brief, but when we speak about the use of the evidence, the chamber relied on evidence that they feel corroborates, but it corroborates nothing at all. The chamber is relying on evidence, but it's transforming it, and this is exactly what I've been condemning since the beginning of these appeal hearings. So please don't tell me today that this is rhetoric and that we haven't supported our statements. If the prosecutors don't agree with us, of course, that's their role. But don't tell me, please, that there are no specific elements on the way that we have extracted from the Chamber's reasoning and proved that the Chamber did not reason in a proper way. And this is something I wanted to stress regarding the facts that were discussed yesterday. A last point, or two last points, more specifically, regarding the jurisprudence that was mentioned regarding the issue of the scope of in dubio pro reo when we speak about the constitutive elements of the crimes or when we speak about liability. The International Court Prosecutor quoted the Stakic jurisprudence, and yesterday I said that this was isolated jurisprudence, but I forgot to specify that in paragraph 416 of this jurisprudence on which the prosecution relies to say that it's only on the facts that the principle of pro rubio applies, in paragraph 416 there is no source, there's no legal base in this paragraph. It's an assertion without any kind of legal ground to say why the principle of in dubio pro reo should not apply. Then, regarding the issue of the soldiers who are hors combat, the co-prosecutor says to us that the Martich jurisprudence does not say what the defense is stating. I'd like to remind you, however, that the facts in Martich is why are we speaking about hors combat and people who are in combat, because in Martich we're speaking about an armed conflict. This is not the situation here with this trial. So the co-prosecutors cannot rely on this jurisprudence. Another point regarding the issue which was discussed even today, which is how must a chamber reason with regard to extermination if there is no prior characterization of murder. Yesterday, I heard from the co-prosecution the Limache jurisprudence that has nothing to do with extermination and which is connected with just identification. But here, I'd like to refer you to the Bossora appeal judgment, which focuses essentially on extermination and on the different sites and how one should proceed to characterize this. In paragraph 396, for example, of this appeal judgment, the way the crimes of murder and extermination should be articulated when crimes are committed in different sites. And what transpires from this jurisprudence that the chamber first must deal with the crimes in an isolated way to qualify them as murder, and then conclude that the crime of extermination is constituted, or if the criteria of massivity is not fulfilled, adopt a global approach and say that the sum of the different murders that occurred in different locations in view of the evidence makes up a crime of extermination. And here, well, I know it's that we are in an appeal hearing and I'm speaking to you about law. I'm not here just to give you a demonstration. And I'm speaking to you about how the evidence can be linked or not to my client's liability. Whether there were, of course there were atrocities, I understand that. And of course horrible things happened during the evacuation. That, of course, we never challenged that. But, please, when you speak to me about Que Sampan's desire for these crimes to occur, that is completely erroneous. And here I'd like to react to what the co-prosecutors did not say yesterday. That is to say, was there a dolus eventualis in 1975 with regard to the crime of extermination? I didn't hear the answer to that question. So it's true that law is something that's complex, but we're speaking here about law because this is a court of law. And under these conditions, the dolus eventualis, stating that the conditions of the evacuation that might possibly have led to the death of several people, well, can that constitute an element with regard to extermination? No. No, certainly not with regard to the law that existed in 1975, and these are concrete grounds for our appeal. I'm not going to, of course, give you the full submission once again. I cannot plead in a few minutes the content of our appeal brief, but please read again the articulation that we make between the facts and Cussampan's liability and the law, and you will see that the Chamber's construction is flawed because there is no proven mens rea. And the Chamber's just scattered the elements. And I was going to forget this, but even with regard the meeting about the evacuation, the Chamber says, look, Cussampan somewhere in 1996 maybe, Cussampan gave an interview and he said that if not everybody had agreed, or if one person had disagreed, we could have stopped the evacuation. But who was Cussampan speaking about at that moment? He's not speaking about everybody in general. He's speaking about the standing committee, a standing committee that he was never part of during the entire duration of the DK regime. And even more so because since we're speaking here about the decision to evacuate Phnom Penh before, whether it be in 74 or the beginning of 75, but then, as I reminded you, he was not even a member, not even a full rights member of the Central Committee. Even if the decision had been taken by the Central Committee, which was not the case, even if that decision was taken, he had no voice in that. So he could have contested it, but on which basis, on which criteria? So these are the facts with regard to Cussampan's involvement. This is the way the Chamber manipulated law, and why this manipulation? Why can we find this manipulation throughout the entire judgment? An example, democratic centralism. The Chamber explains to us, yes, that everybody was taking part in all decisions, whereas we had witnesses who came here and who explained that in the end the decisions were in the hands of the Standing Committee, and in particular in Pol Pot's hands. And they're telling us that, okay, everybody could decide on everything. Why? Because at one point we have a hard time finding the link between Cussampan and the facts, Mr. Cussampan, and the decisions. So this is what we're telling you now in our appeal submissions, and this is what you will find in our appeal brief, with elements, with references that we cannot develop further in the few minutes that are given to us here, but that do exist. This is not rhetoric. We have come up with a demonstration which the prosecution may not like, but it is a demonstration. Of course, now I'm open to the Chamber for its complementary questions, but these are the points that I wanted to remind you of in relation to what was said yesterday and today.
Honors, I would just note that I understood that counsel is just replying to what we submitted on individual criminal responsibility. There was nothing in the schedule for that. We didn't object to it, but we would like an opportunity to briefly respond to what she just said. I'm not going to cover everything. But for example, she did rely upon the testimony of someone called Ni Khan. We'd point you to footnote 359 of the judgment. Ni Khan was the brother of Sun Sen. The trial chamber there found his testimony inconsistent and therefore unreliable. I'd also point out that counsel is saying that it's important to put Cussampan's statements in context, and absolutely we agree with that, and that's exactly what the trial chamber did. You have to put his statements in context. So when he talks about the necessity to kill the traitors and kill the enemies and the last chance for others to join the Khmer Rouge or share the same fate, it's important to put that into the context of how the increasing brutality of the Khmer Rouge regime from 73 to 75 and the pattern of executions of Khmer Rouge soldiers. When Cussampan goes on the radio and talks about the great victory after the 17th of April, it's important to put that in context of the absolute misery of millions of people in Phnom Penh who, because of that, what he called great victory, were dying, starving, being displaced from their homes, on the roads, and he's passed them in his car on his way into the city. He himself saw this. So put into context that Khieu Samphan's statements promoting this joint criminal enterprise were done with the full knowledge that of the crimes that were occurring. There's a saying in Khmer, I understand, that the back foot follows the front foot. And my understanding is that means that subordinates follow leaders, or sons and daughters follow their parents. Khieu Samphan, at all times during this indictment period, had a very key role. He was, and he admits it, the face of the Khmer Rouge. He even had the title of Commander-in-Chief, even before 1975, of the Funk forces. He was the person speaking on their behalf and known both to foreigners and to the people of Cambodia. And he was the one promoting this enterprise while all these crimes were going on, excusing the crimes and encouraging the crimes. So we agree with counsel. It's very important to put his remarks in the context of the brutality of that regime.
President. The chamber will now move to the semantic session on the sentencing. And I'd like to invite the co-rapporteurs to present the report.
Mr. President, the grounds of appeal related to sentence. This is the report of the chamber. The trial chamber sentenced both accused to life imprisonment. Only Khieu Samphan raised arguments specifically against his sentence, which he argued taint the trial chamber's exercise of discretion. First, Khieu Samphan recalls that the trial chamber sought to reassure the surviving victims and their families, the witnesses and the general public that the law is effectively implemented and enforced and applies to all regardless of status and rank. Khieu Samphan argues that the statement shows that the trial chamber forgot that the accused person should be at the center of the sentencing decision and not the general public, and that it did not strike the correct balance between deterrence and retribution as purposes of punishment. He argues that the alleged errors are emblematic of the trial chamber's purported bias against him. While denying the allegations against him, he argued, secondly, that the trial chamber failed to take into account Khieu Samphan's individual circumstances and his alleged limited participation in the crimes. He argued that he should not have received the highest available sentence with reference to the sentencing practices of the International Military Tribunal and the ICTY, given that he was not one of those most responsible perpetrators. Thirdly, he argues that the trial chamber erred in its assessment of aggravating and mitigating circumstances, notably by erroneously taking into account his position of authority and his level of education, and by failing to give weight to his good character. In respect of the latter, he argues that the trial chamber's references to his purported good character are contrary to its earlier findings that Q Sampan was indeed trusted and respected. In Q Sampan's submissions, all these errors invalidated his sentence imposed by the trial chamber. Mr. President, thank you.
I'd like now to hand the floor to the Defense Counsel, Madame Anta Kuse, to make your submission.
Thank you, Mr. President. Mr. President, Your Honors of the Supreme Court Chamber, it's never easy when we plead for acquittal to also plead at the same time, even in a subsidiary manner, on the quantum of a sentence which by definition we have just explained to you should not be inflicted upon our client. However, criminal justice being the way it is necessary to come up with subsidiary solutions, and we're doing so even more so because even with regard to the issue of sentencing, the Chamber erred in law and in fact. As in the rest of its reasoning, the Chamber sinned by favoring symbol over law. And here once again, the Chamber forgot that the sentence concerns the person above all, the person who is going to be subjected to it. And this is the mere principle of the individualization of the sentence. I'm not going to be very lengthy about this. I simply like to recall our paragraphs in our appeal brief, paragraphs 646 to 658, by reminding you that our criticism is multi-layered, which is the ignorance of the reason of the sentence, absence of individuation of the sentence, errors regarding the aggravating circumstances, in particular abuse of authority and level of education, and absent and failure to take into account mitigating circumstances. The prosecutors submit that we haven't demonstrated how the Chamber abused its discretionary powers, and they quote the Duke appeal judgment, in which the Milosevic appeal judgment is quoted. However, according to this jurisprudence, we can and we should demonstrate why there was an apparent error of discretion. Error with regard to the objective of the sentence. A sentence is about dissuasion and punishment. That's what Nikolic says in paragraph 132. But this does not mean that the accused person or the sentenced person should not be at the heart of the sanction. He must be at the center of the objective of the sentence and not of the outside people, such as we read in the judgment. And an important point here is that during its trial, the Chamber was obliged to acknowledge that Sampan, during the decay regime, only had a symbolic position. The Chamber was not able to find that he had any kind of hierarchical authority over anyone and did not draw the consequences of this. And necessarily, because we are here before an international tribunal, we are referring to the jurisprudence of other international tribunals, and we reminded you in our appeal brief of the Funk in the Nuremberg jurisprudence, which is very evocative because there may be some kind of parallel if our client is sentenced. Funk was sentenced for crimes of war crimes, crimes against peace, and crimes against humanity, and he was a member of a body that ordered slave labor and to be deported, but in the context of its judgment, we saw that he never played a key role in the different programs that he might have participated in. And it is under these conditions that he was given a limited sentence. And I'd like also to refer you to the Galich appeal judgment of the ICTY, paragraph 438 to 456, in which we can see, or which it is stated, that the only life sentences that were handed down against individuals who had the highest authorities and responsibilities, and that they had a clear power over the commission of the crimes. And this is not the case with Khieu Samphan. And I would like to remind you, with regard to this, that the supposed determining role of Khieu Samphan was not demonstrated at all in the commission of the crimes. So, of course, the point here is not to reproduce the decisions from other courts, but simply to note that the rather faulty reasoning of the co-prosecutors, who are telling us that, yes, the gravity of the crimes would depend on the geography and the date. Here I must say that I'm a bit confused and disturbed by this argument, because I cannot see how we can say that it would be worse to kill in 1975 in Cambodia than in 43 in Germany, or in 91 in Yugoslavia. That is not the real question. The real question is not geography. The real question is the character of the accused. And the question is, did he play a main role? And what was his degree of participation? That is the question. And this leads me to another error, or to stress another error from the Chamber, because the Chamber retained as aggravating circumstances the supposed authority of Khieu Samphan. And here I'd like to remind you of the Milosevic appeal judgment, paragraph 302, stating that authority, even at a high level, does not necessarily justify a harsher sentence, but the abuse of this authority, of course, can make up an aggravating circumstance. But we have to note that never the Chamber has explained which authority Khieu Samphan enjoyed, and even less so, which abuse of authority he demonstrated. And I'd like also to refer you to the Katanga decision on sentence in paragraph 75. I also like to refer you to the Sinovic appeal judgment, paragraph 1802. And the constant jurisprudence is clear. Abuse of authority is the only aggravating circumstance. It's not authority, it is only abuse of authority. And this was not proven in this case. Another error from the Chamber: the degree of education of Khieu Samphan, which is considered as an aggravating circumstance in this case, but the Chamber is basing itself on no legal ground, nor in international law, nor in national law, to explain how this constitutes an aggravating circumstance. However, the Chamber once again erred by not taking into account Khieu Samphan's character and everything that was said in the proceedings regarding that. And of course, there are the character witnesses who testified and who spoke about Khieu Samphan's character, about his human qualities, but also not only the character witness, but here I'd like to refer to paragraph 656 of our appeal brief, and this is quite rare in a case such as this one. All people who came to testify before this Chamber always spoke about Khieu Samphan's human qualities, about the fact that he had no power, and about the fact that they never saw him say anything negative about anyone. These qualities, these elements, in relation to his absence of authority, should have been taken into account by the trial chamber, and they were not. And therefore I would conclude by saying that, of course, these errors should invalidate the chamber's decision with regard to the sentence, but I would not be complete if I did not finish where I started. That is to say that in our eyes, all of the elements that we have developed over the past 3 days cannot lead to a conviction of Khieu Samphan, you must invalidate the judgment in its totality and acquit Mr. Khieu Samphan.
President, let we have a short break. We have a 20-minute break now, and we will resume at 20 to 11.